I wod like to ask our panel members to give us their thoughts on some key takeaways for this event for the benefit of our attendees. And I'd like to do it, if we could start with Stephen Lee. Stephen, some final thoughts?
Yeah, sure. And, first of all, thank you for giving us this opportunity to talk to you all about AI and eDiscovery, which I know I'm very passionate about, and I know Jonathan is as well. I could talk for days and days around this. And I think you heard me say this already, so I'm sure it's come out from my presentation. But the areas that I really feel very strongly about is, one, moving further left of the eDiscovery program. So I encourage you to ask yourself and perhaps internally discuss among yourself within your organization, where does your eDiscovery program start? Does it start at the point of data collection, at the onset of some litigation or investigation, or does it start from day one when documents are being created by end users? Really consider that from early on. The second question I would ask is, how are you currently using machine learning? Obviously, electronic data is growing exponentially, and quite often the challenge is getting that initial investment from management to go in and invest in and implement some kind of a machine learning algorithm, or technology. So if you're able to do a little bit of a benefits realization analysis, I think it would go a long way in showing that a little bit of investment up front in terms of doing that auto classification and getting machines to understand documents quicker than humans can, I think is going to go a long way. So really ask yourself, how much have you pushed your organization, and how widely are you currently adopting machine learning? So that's the second point. And then the third, I would say, is the data insight. I'm a big believer in data insight, where my tagline is make decisions based on data insight as opposed to just making instinctive decisions. And traditionally, where you have so much data out there to digest, and information that's out there in the public space and also your organization data, to be able to bring all that in, I think gives you so much more insight to make decisions, and also effectuate some of the organization policy changes that one of the listeners asked about as well. So that would be my kind of third key takeaway point for everyone, is to really consider all those and think about how you could bring more data insight that's based on true facts that's available to you, as opposed to just making instinctive decisions. And that is going to lead all the way through your investigations and cases as well.
Thank you very much, Stephen Lee. Jonathan Moss, would you take a minute or two to discuss your key takeaways?
Yes, and likewise, thank you very much for this opportunity. It's been enormous fun and hopefully very useful for the listeners. Perhaps not surprisingly, I don't particularly disagree with anything that Stephen has said. I would like, though, to highlight the fact that I think that the very niche area of electronic discovery, electronic disclosure, is going to overflow into many other business areas, as the understanding of what the technology can do and the expertise that those who can deploy machine learning and use AI or find problems to which AI is the solution become in much greater demand. So for all those who are eDiscovery practitioners or want to be, and who thought that it was going to be a narrow use, I think you're about to explode onto the general business scene. I also think that the use of the technology is going to become increasingly everyday and increasingly less the subject of webinars and conferences, as people accept that this is how we do it. I think that it's going to lead to a host of other improvements in the area. For instance, I agree completely with Stephen's comment about there being greater insight into the data, but what that would also lead to, I think, is a greater understanding much earlier in whether there is a case to deal with, either to defend or to prosecute. So we may see a bit of a drop-off in use of the courts, like we saw in 1999 in England, when there was a significant rejig of the civil procedure rules. Court attendance dropped quite dramatically. I think we will start to see, with this early insight, the ability for vendors to provide much more accurate estimates of how much it might cost to undertake various tasks. And I think that process, certainly in the UK, will make litigation funding a considerably more attractive prospect for those who engage in that, because they can have a better surety of the return on their investment, because they will have better insight into what it is that is involved and what the matters are around which there is a dispute. So I think it's, without being any more specific, I think we're seeing the beginning of an easier life for lawyers and a more interesting life for lawyers as they start getting back, hopefully, to the process of analysing the facts and actually lawyering rather than wading through massive numbers of documents, hour on hour, day on day, week on week, which is soul destroying.